I allegedly shot and killed my uncle, or my uncle killed himself. Let's talk about that.
Tom killed himself, and he literally gave me the bird. And then the state of Florida decided that I must have killed Tom for his money. And they have been giving me the bird ever since.
Assisted self-murder is not a lesser included charge of murder, premeditated murder. Since being charged in December of 2022, I've been told that I, with premeditation, killed my uncle. I decided to tell my story at this point in time because of this new charge, an assisted self-murder charge, because it seems extremely unfair to me, not only because I'm self-represented and part of the state's plan was to keep me in jail for a week, which didn't work for them, but they did keep me in jail for a couple of days. But beyond that inconvenience, there are significant differences. So to explain to you, the first thing I've asked of the state is that they provide some statement of particulars. This is a motion asking for some information from the state as to what it is I allegedly deliberately did. I feel that if they're going to charge me, especially if they're going to be charging me more than 3 years after my uncle's suicide, they're not doing additional investigation. They ought to know what it is they believe I did that assisted him in his suicide. So that's the first motion that I brought. The judge is going to have to either grant that motion for a statement of particulars and order the state to respond, or he will deny my motion and it will remain a terrific mystery. Ideally, I would have waited for a ruling by the judge and move forward from there. Happy hour is running late. Lolita is letting me know that he has not missed what time it is. So Lolita, just give me a few minutes. I filed for a motion for particulars. And again, I would have ideally waited to file the second motion, which is a motion to dismiss. This motion to dismiss explains 3 different bases why I don't think it is fair for the state to move forward with this charge and why I think the judge should dismiss it outright. This is a motion that you can bring prior to arraignment, prior to agreeing that the court has jurisdiction over you. I stood mute at my arraignment. I did not enter a plea of guilty or not guilty. I instead took some procedural steps. When a person is arraigned, there are several options. It's not simply a time where you can either plead guilty or not guilty. You can also plead no contest. Well, one of the other things you can do is you can say, I'm not going to plead anything at all. I'm going to stand mute. I am not willing to accept that I am subject to the jurisdiction of this court in this matter. And that is what I did in this case. I have filed a motion for a statement of particulars and motion to dismiss. Now, the motion to dismiss argues that this charge has been brought more than 3 years after my uncle's suicide. There is a 3-year statute of limitations. There are some ways for the state to argue that they should be allowed additional time, that the timing would have been told for a portion of the time. I disagree with their thinking on that. And then there is also the due process right of a defendant. So this says that no person should be tried without the due process of the law. That is a more significant right, harder for a state to argue against, also harder for a defendant to argue has been violated. There's more to prove, whereas just a statute of limitations violation, generally you just would look at a calendar. But again, there are bases to toll. So there are those 2 issues. And then the third issue is that I can't tell what it is that the state thinks I allegedly did to assist Tom in his suicide on this new charge. So this goes back to the motion for particulars in which I'm asking the state, hey, you need to tell me what it is I allegedly did to deliberately assist him. I'd love to hear what it is that they think I did that rises to the level of criminal culpability. I think it's important for us as a society. We have an aging population. We also have many different iterations of family and friend. And many of us could find ourselves in a position where we when someone else takes this drastic measure. So we need to have a clear understanding of what it is that would result in criminal liability. And I feel that I'm entitled to that information. Since being charged in December of 2022, I've been told that I, with premeditation, killed my uncle. Now, the state's argument for bringing this new charge against me, to me, smacks of disingenuousness. According to the state, a statement made by the state's attorney who was present for my bail hearing. So when you are arrested, there is a magistrate judge, in this case, who heard mine and many other people's bail consideration. And it's a formal process. There is a public defender there to assist those who require assistance. A few people bring in private attorneys, and then there are people like me who say, I'll speak on my own behalf. So at my bail hearing, you have to remember now the state had asked for me to be held without the possibility of bail. Now they asked this of the magistrate court and said that they would get me before a full fledged judge the following week for a hearing on the matter. The problem for me was that I had 4 depositions scheduled for the following week that I would miss. And these depositions took considerable effort to schedule. And I've been waiting for a long time to be able to take those depositions. So I did not look forward to missing them. The magistrate judge agreed with me and granted me bail for an additional $100,000. But I think it's worth taking a look at what it is that the state said as to the reason why they were bringing this new charge. So I have to put on my glasses to read this to you. This is the statement from the state's attorney at that bail hearing. Let's see. The basis for the state under Florida statute 907041 that we're seeking this detention is that the state has done legal research and we've made the determination, it's our belief, that this charge is not a lesser included offense of the first degree, so she can be charged with this additionally. All right. What does he mean here? The state's claim is that up until now, they didn't understand that assisted self-murder is not a lesser included charge of premeditated murder. The way the murder statute is written is that there are degrees. At the top, the Mac Daddy of them all, first degree murder, also called premeditated murder, which includes premeditation. Some thinking or planning, some decision that's been made by the defendant to commit this crime. It sweeps in felony murder as well, which is where if 2 people, Fred and Barney, decide they're going to rob the liquor store and Fred doesn't know that Barney's packing heat and Barney kills the security guard, as all too often, unfortunately, happens, then Fred could also be held responsible for that person's death, and he could be held to this higher standard because of Barney's premeditation. So there are some other exceptions. But the important point of premeditated murder is the premeditation. Now, the other elements of that crime you find in the lower level of second-degree murder. It has all of the same elements. There's still killing, and there is still the person causing that death. But instead of it being a premeditated act, we call it a depraved heart or a depraved mind murder. Below that, we have manslaughter. And there are all kinds of variations of manslaughter. But the important point for our discussion is that in manslaughter, which could be voluntary or involuntary, in manslaughter, we have a decedent who has been killed, and the actions of the defendant caused that person's death, whether intentionally or unintentionally. What do we see? We see things stacking one over the other. Starting at the bottom, you have manslaughter, and every element in manslaughter is included in second-degree murder, and every element in second-degree murder is included in first-degree murder. Each new level has one or more ingredient. So, what about assisted self-murder? Although it's found in the same statute as, and it's even described as a form of manslaughter by the Florida legislature, what are the components of assisted self-murder? The victim is dead. The victim committed self-murder or suicide, and the defendant did something to assist the victim in that self-murder. So you see the big difference here is that for assisted self-murder, the defendant, namely me, has not killed the decedent. So while the state of Florida may find this revelation shocking, I really don't think they should. There are very few cases in Florida's history in which a person has been charged with assisting self-murder. And because of that, there's even less case law related to it. Florida's had an assisted self-murder statute since 1868. 1934, there was a case, Patrick v. State. In Patrick, the citation there is 117, Florida 432. The Supreme Court found that in that case, an indictment charged the defendant with actually shooting the victim. And it was an error then to charge the jury on a theory of assisting self-murder that involved the victim shooting himself with the assistance of the defendant. And this ruling basically found that you can't move, in that case, it was a gun, as it is in my case. You can't move a gun from one person's hand to another. They are two different things. In 1992, the case Reagan v. State, Ragan v. State, made it to the Second District Court of Appeals here in Florida. And Reagan cites back to Patrick v. State. In Reagan, the defendant was convicted and he said, hey, that trial court made a mistake. It should have given the jury instruction of assisting self-murder so that they would have had that as an option by which to sentence Mr. Reagan. And the Court of Appeals in Reagan said, no, we don't move the gun from one person's hand to another. And in this case, Reagan has stated that he is the one who fired the weapon. That's about the whole history that I could find related to the interface between a murder charge and an assisted self-murder charge. I think it's clear the elements are so different. In one, my uncle killed himself. In another, what I've been dealing with since I was charged in December of 2022, I allegedly shot and killed my uncle. So that is why I've asked the state to dismiss this late charge, because they are radically different theories of liability and radically different forms of proof are required. If you are speeding in another town with which you're completely unfamiliar with their traffic laws, you're speeding down the road and you get pulled over and explain to the officer who's pulled you over, I didn't know that the speed limit was 30. He's going to tell you that not knowing the law is no defense. So here, the state charged me with a very serious crime. And in my mind, they ought to know what it is I allegedly did to merit this charge. They ought to be clear what actions I took to be sitting here more than 3 years later, fighting that I'm not thrown in prison for something I didn't do for the rest of my life. And certainly at this 11th hour for me to defend myself against this new charge, which is so different, would require me to stop everything. I mean, as it is, just to write these motions and to give the court enough information and to do the adequate legal research to support my position took me off task of working to defend myself in my premeditated murder charge case. So the state got what they wanted there. They busied me with this stuff, but I'm hoping they don't get to do it any further because to me, it's highly prejudicial. I do not have an incredible staff. I have a paralegal who mostly just chews paper or poops on it. Either way, it's not that helpful. But I don't have legal staff assisting me, and therefore it would be even more onerous than it might be for some. So that's kind of the background that we have from the case law. And if I could find this, I should think that the state's attorney's office in Broward County could have been able to find this. And certainly they could have done so sooner than they have in this case. So where we are now, I am waiting for the trial court to rule on the 2 motions I have filed in the new case. I hope that explains things. And we'll see what the court chooses to do with these 2 motions. Ever the optimist, I want my trial date. But I also recognize that many other roadblocks may get in my way. There is my motion for the statement of particulars. There is the motion to dismiss, and there are motions in the works in my 2022 case. Any of those could end with rulings by the trial court that lead to the state appealing, maybe even me appealing. I hope that walking you through these legal proceedings have made it easier to understand what is happening in my case. And if you have questions, please message or comment, and I will try to respond. This is, of course, an ongoing legal case, so there may be some limitations to what I'm willing to say at this point. But for the most part, I feel like I don't have any secrets because I didn't do anything here. I should say that it's this new charge. It so shook me as an American and as an attorney that the state would do this. It just felt so wrong. Got home from jail and started looking for cameras to purchase and lights and a microphone so I could tell my story. So here I am. Thank you for being here. I'm Shannon Gallagher, and this is Giving Me the Bird.
Ooh, I can't wait to get up and get out of here. The system tapped into my deepest fears. Never be here again, I swear. I'm so mad, but under that I'm scared. Stole my old life has disappeared. Is that a feeling that you've ever shared?